from Chicago is suing a bunch of people over posts made about him in the Are We Dating the Same Guy Facebook group, and it has stirred up so much controversy.
It all started with the viral sensation of West Elm Caleb back in 2022, where tons of women made viral posts about how they'd all been allegedly dating the same guy. Following this, tons of Are We Dating the Same Guy Facebook groups popped up, and now exist for almost every major city and include 4 million users.
Members tout it as a helpful place to learn about men in their area, to see if they're actually dating other people, if they have any red flags, or even histories of abuse. But critics say that the groups invade men's privacy, and that they can cause serious harm because the allegations aren't vetted.
Which is precisely what this man has claimed in his lawsuit. He says that his photos and name were posted all over the group, with numerous women saying that he's clingy or obsessive, referring to him as a psycho, and even posting screenshots of their texts together. You can form your own opinions here, but the law is actually way more complex than you might think.
We've seen a lot of people talk about how truth or opinion are defenses to defamation, meaning if what users say is true or is just their opinion, then they're safe from this lawsuit.
That is true, but this case isn't just about defamation. The man also invokes a brand new anti-doxing law in Illinois, which makes it illegal to post someone's personal information without their consent if the intent of the post is to cause harm. And as a result, the person might experience death, bodily harm, or stalking. And the person does in fact suffer some kind of life disruption.
This is a pretty vague law, and it makes no exceptions for true statements or opinions. So the man's case could arguably apply.
But even if it did, it might not matter, because some have argued that this new Illinois law unconstitutionally restricts free speech. The First Amendment does generally allow you to put someone on blast online, even if your intent is to cause them harm, as long as the stuff you're blasting is actually true.
For example, think about reporters who broke the story on Epstein. So the main issue here may not be whether this man wins the case, but whether that law is constitutional in the first place. A federal judge has just ruled that it's a violation of the Second Amendment to ban guns in post offices.
This all started when a postal worker from Florida was arrested for illegally carrying inside of a post office. The worker had a concealed carry permit, and he said he carried for self-defense purposes, which might make sense to some, given that violent attacks on postal workers have been on the rise. But a federal law made it a serious crime to possess a firearm inside a post office.
Why? Well, quick bit of history for you. Ever heard of the phrase going postal? This actually originated from a weird period during the 1970s and 90s, during which postal workers kept going crazy and shooting up post offices. Morbid.
Anyway, the federal judge relied heavily on the infamous Bruen decision from 2022. Under this new Bruen standard, a gun restriction is only valid if it's part of the historical tradition of the Second Amendment. In simpler terms, judges today must act as quasi-historians to see if a gun restriction today would have made sense at the time of the Second Amendment's drafting. So this judge said there was no historical support for banning guns in post offices. In fact, she pointed to old-timey train car robberies and even the Postmaster General arming mail workers with government-issued firearms.
Now, what happens next here? Are gun bans in other federal buildings going to be ruled unconstitutional? What about courthouses? Will we be seeing armed defendants at trial?
Probably not.
Because in the Bruen decision, Justice Thomas explicitly mentions that courthouses are one of the places where gun bans make sense.
Convenient.
Which completely bamboozles this man.
Because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it, I never would. That's all I gotta say. I would never do it. I'm innocent.
Okay, first thing to explain here is this man's at a sentencing hearing. He's already been convicted by a jury of killing his 15-day-old daughter. The whole case here is horrific.
So the man uses his chance to speak at this hearing to proclaim that he's actually innocent. But then the judge interjects and asks him this question.
I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
Think about that for a second.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement, consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
You can tell by this guy's facial expression at the end here that he realizes what the judge just did. And this whole situation actually illustrates the important difference between a judge and a jury.
Juries decide who's actually guilty or not, and then it's up to a judge to take that jury's verdict, accept it as valid, and decide what sentence is warranted. Single federal employee is denying a man the only cancer treatment that could save his life. That might sound hyperbolic, but it's not.
I'm a 41-year-old American and a new dad with an aggressive cancer called acute myeloid leukemia, or AML.
So this man has leukemia, and the treatment he needs to save his life is a bone marrow transplant. Through a special organization, he found a donor who's a match for him, but the donor lives in the Philippines.
The video goes on to explain that a visa for the donor was denied by the State Department twice, even though they provided the U.S. Embassy in Manila with all requested information, plus letters from his doctor explaining that the travel was life-saving and urgent, letters from the donor matching organization, and letters of support from members of Congress who knew about this man's case.
And yet the visa was still denied. Okay, so you might be thinking this sounds totally absurd. Is this visa applicant actually a terrorist or something? Well, according to the man, no. He says the reason listed for the rejection was Section 214B, which is just the blanket catch-all reason for a denial.
You might not know this, but just traveling to the U.S. can be extraordinarily difficult for foreigners.
If a foreigner lives in a country that's not part of the visa waiver program, like the Philippines, they'll need to apply for a visa just to step foot within the U.S. And that process process can be super laborious, requiring numerous applications, fees, photos, medical clearances, and even in-person interviews. And the decision whether to give a visa or not usually falls with a single consulate officer, just some regular employee who might happen to be a dick. And there's no appeal process.
Anyway, the man asked everyone to share his story to bring more attention to it. You can also go to the White House's website and send a message. So super fake, super sexually explicit AI-generated images of Taylor Swift just went viral online. Reports say she's not happy about it, which is fair, and she's even considering legal action.
So how would that work? How the hell does the law, this often antiquated set of rules written by a bunch of geriatrics, possibly handle evolving AI technology and deepfake content?
Well, there's no current federal law regulating this, but several states have actually recently passed laws making it a civil offense, or even a crime, to create and distribute fake sexual images without consent.
In addition to these new state laws, a creative lawyer could take traditional laws and apply them to deepfakes. For example, false light and privacy claims can apply when someone publishes something about you that's false or misleading and also highly offensive, like creating and posting fake sexual images of you.
So for Taylor Swift, legal action will likely depend on what state the content creator was in, and how creative her, no doubt to be very expensive, lawyers want to be. But it's important to note that if the creator of these images lives outside of the US, Swift likely won't have any legal recourse against them.
She'd also have a hard time suing any platform that hosted the content, because this law generally protects platforms from liability based on what their users post. Anyway, some people are actually really wary about the law and government getting involved with regulating deepfakes. They think this will just lead to more government censorship on the internet.
Others also argue that this content should be protected by the First Amendment. They'd say that creating deepfakes is not materially different than creating a super realistic painting of a naked celebrity, which is legal.
The counterpoint here is that everyone knows a painting is fake, but AI generation could get so good that people think those are real. For now, no federal court has ruled on this issue, so it's still an open question. Does everyone understand how fucking nuts things are between Texas and the federal government right now?
Don't joke about that.
Okay, but just to give 3 examples. First, the Texas Military Department, which, yes, is a real thing, has taken over a section of the border in Eagle Pass, one of the most popular areas of illegal border crossing, and literally kicked out the Federal Border Patrol, prompting the Department of Homeland Security to threaten to sue Texas. To which the Texas governor responded, Texas will not surrender.
Second, Texas passed a new state law, the first of its kind, which makes it a state crime to illegally cross the national border into the state. And this law isn't just a form of political theater. Reports say that arrests have actually been made by state authorities under this new law, prompting the federal government to actually sue Texas.
And finally, third, Texas has constructed its own buoys in the Rio Grande River to deter border crossing, even though the federal government said they couldn't. And then Texas started putting up razor wire along the border, but the Border Patrol kept coming and tearing it down, leading to this viral footage.
This time, Texas sued to get the Border Patrol to stop. But just hours ago, the Supreme Court ruled that the federal government does have the right to remove the razor wire. In response to the ruling, the Texas governor stated, "This isn't over. I'll continue to defend Texas's constitutional authority to secure the border." Baldwin has been indicted for involuntary manslaughter again for the second time, which brings up the topic of double jeopardy.
And one of the most interesting legal loopholes out there. So Baldwin's first involuntary manslaughter charges were dropped last year, but now he's being charged again after prosecutors got a new analysis of the gun used in the deadly shooting, which they say provides some new damning evidence.
But can they really charge someone twice? Well, double jeopardy is a legal protection found in the Fifth Amendment that says defendants cannot be subject to the same offense twice. The problem for Baldwin is just being charged with the same crime doesn't trigger double jeopardy. Prosecutors can bring charges, drop them, and then bring them again if they want.
Double jeopardy generally only applies if prosecutors bring charges, then take you to trial and lose. If that happens, they can't just say, oh darn, well, let's try again until we get a guilty verdict.
Or can they? There's a legal loophole here called the dual sovereign doctrine.
This doesn't actually apply to Baldwin, but I find it fascinating, so we're going to talk about it.
It's my hot body, I'll do what I want.
So under our federalist government, there are always 2 separate powers or separate sovereigns, the federal government and each state government. And even if one sovereign, say the state of Utah, brings someone to trial and loses, that doesn't prevent another sovereign, say the federal government, from also trying.
For example, back in 2010, a man shot and killed a police officer in Utah. The officer was a woman and the defendant was an illegal immigrant with a violent criminal history. Suffice it to say, strong emotions surrounded the case.
Utah state prosecutors brought murder charges against the man, but shocking everyone, a jury found him not guilty.
But the man's story didn't end there. The feds stepped in and charged the man themselves.
ATF agents provided special ballistic evidence to reconstruct the scene and show that the man had died. And this time, the jury unanimously found him guilty for the same crime he was acquitted of years earlier.
And he was sentenced to life in prison by a federal judge.